missed you guys. I really have. I'm so excited to be here with you on today's podcast of HR in the Dark, where we expose the dark side of human resources and the things that go on in the back corners that nobody wants to really talk about. I am Stephanie Lomax, your host of the podcast, HR in the Dark, CEO and HR strategist for HR Pro for You, an HR consulting firm where we help small businesses embrace HR and build legally sound and scalable HR infrastructures. Today's podcast is all about piercings, tattoos, and striped hair. Oh my! We're talking about dress code policies today. And I'm excited because this is actually part one of two parts of the podcast because there's so much information that I did not want to leave anything out. So I'm making sure that I get you all of the good details into full 15-minute or less episodes. So today we're talking about dress codes, right? It's getting warm outside. The weather is breaking here in the Washington metropolitan area, and people generally start shedding a few layers of clothing. Not such a bad thing necessarily, but we want to make sure as a small business or a business in general that our dress code policies, number one, speak to what image it is that we want to portray as a business, but then also that it's legally sound. So we're not enforcing, or we have not created dress code policies that violate laws. How is that even possible? I'm sure you're asking. Well, I'm so glad that you asked, because today we're going to talk about what it is an employer can and cannot do, and what their policies can and cannot enforce as it relates to dress code policies, grooming policies. And then also in this first episode, or this part one of this podcast, we're also going to talk about what kind of accommodations an employer has to make when it comes to dress code. So let's dive right in, all right? So the EEOC, Equal Employment Opportunity Commission, and Title VII of Civil Rights Act of 1964 have very specific requirements in terms of what employers can and cannot do when it comes to national religion, sex, gender, and a bunch of other pieces of legislation, and a bunch of either protected classes. And so the laws basically are outlined to protect the employee so that they are not discriminated against because of any of those protected classes. Can an employer have a dress code policy? Certainly, they can have a dress code policy. They can have dress code policies that speak to uniforms. If there's a specific uniform that's required to be worn, i.e. many of the fast food restaurants that you see, obviously they're all in uniform. Clothing stores, retail establishments may have uniforms. A lot of spas and salons have, uniforms they have to wear. Hospitals, they have scrubs that they are required to wear. Certain other industries, construction has to have certain type of boots, have to have certain type of personal protective equipment, or PPE. And so there are specific things that some industries and establishments require in terms of dress code. Generally, an employer can have a dress code policy. Doesn't mean that you cannot have one, but what cannot happen is you cannot violate anybody's rights as it relates to national origin, religion, and even disability when it comes to enforcing the dress codes. Grooming policy, same thing. Can a person wear a really long beard if it's part of their religious practice in a workplace that handles food, for example? Is that against the workplace policy? So generally, I just want to say this: have a workplace policy that that reflects the image that you want to portray to the public at large. If you are a laissez-faire organization, you have casual every day, you don't do business dress, great, no problem. Make sure that you are enforcing that fairly and equitably across the board. If you are a suit and tie organization, no problem, be a suit and tie organization. If you're somewhere in between where you can do business casual, and maybe you have casual Fridays where you let employees wear jeans, great, no problem. Where the trick comes in is with Title VII and with the ADA. So let's talk about what that means. I'm reading this to you verbatim off of here. So you can absolutely have this dress code policy as long as it does not violate any religious belief, treat some employees less favorably because of national origin, and if they request an accommodation to the dress code, as long as it does not create an undue hardship for you, the employer, you are required to accommodate the request, a reasonable accommodation to the request. All right, so Title VII of the Civil Rights Act of 1964, which I mentioned a second ago, prohibits the following things, and I'm reading these to you. Disparate treatment based on religious practices or belief. Job segregation. Well, what does job segregation mean? Somebody that's dressed in their traditional religious garb and you don't allow them to have customer contact because you feel that your customer seeing that individual in their religious garb could present some type of an issue with them doing business with you. That's against the law. You can't do that. Religious accommodations being made once the employer has been put on notice. So if they say to you, hey, I need to have this accommodation made because of my religious beliefs, then you are required to make that accommodation, as long as I mentioned a second ago, it does not create an undue hardship for the employer. Retaliation based on how they're dressed. So, oh, you don't want to follow the dress code policies because of your national origin, then you don't get an opportunity to be considered for this promotion. That's a big no-no. And then harassment based on how they're dressed. And we all know in today's society, unfortunately, we become so aware of harassment in many forms, and dress code and how people dress and what those clothes and how that dress portrays them and what light, and harassing them based on that is a definite way to end up in court for sure. So what does the Americans with Disabilities Act say, or the ADA? We talked about reasonable accommodations, and I'll give you two specific examples of how that could play out. So a reasonable accommodation is we require all employees to wear long sleeve shirts that are either white, black, or blue to match the uniform shirts that we're going to give you, because those are our company colors, let's say. And so all of the employees are required, if they're to wear long sleeve shirts as a part of that dress code. You have a cancer patient who has recently started undergoing chemotherapy treatment, and the chemotherapy treatment has caused lesions and scratches and scars on their arms, and wearing the long sleeves becomes an irritant for the scars and the sores that are on their arms. They're asking not to wear a long sleeve shirt because of the issue that has come up. Are you required to make that reasonable accommodation? You absolutely are, because what undue hardship is going to come to you as the employer as a result of having this individual not wear a long sleeve shirt? Probably nothing. So that is one example. Second example, you have a diabetic employee who has developed foot ulcers and has a hard time wearing hard bottom shoes or dress shoes or heels, whatever. And they make a request for an accommodation to wear either like a casual shoe, a lace-up shoe that has a soft bottom, a tennis shoe even. And so they have interaction with clients once a week, and their doctor has prescribed that they have to wear a certain type of shoes when they're walking until these ulcers and this diabetic scenario with their feet is resolved. Are you required to accommodate that request? Absolutely, you should, and the law would probably prevail on the side of the employee if it ever went to court, because again, is there an undue hardship for you to allow them to wear tennis shoes? Is it really going to reflect poorly on you that you have a capable employee that has always taken care of the clients, but because of their medical condition, which is none of the customer's business, you don't want to allow them to wear tennis shoes? That's probably not going to fly either. So we want to make sure that reasonable accommodations, once requested, are given in terms of accommodating the employee. The case that I want to talk to you about, and you know I always have one good one for you. So the case that I want to talk to you about is about a young lady in the Denver, Colorado area. Her last name is Elauf. E-L-A-U-F. She's a Muslim young lady, and she applied for a job at Abercrombie and Fitch. This is one of the most well-known established retail brands in the modern decade, I would say. And so maybe a little even longer than that. And their motto in their hiring when they placed ads was that they were looking for people, and I'm reading this verbatim, that have classic East Coast collegiate style. So I think that speaks to a type of person or a type of dress that they're looking for in terms of their employees. Not a problem on face value. However, Miss Alof is Muslim and she wears a jihad, a head wrap. And so they declined her from employment under the assumption that she wasn't going to fit their classic East Coast collegiate style motto because of her headdress. And what did Miss Alof do? She sued Abercrombie and Fitch. And what did the court say? You are absolutely right, Miss Alof. You cannot be discriminated against because you are because of what you wear on your head. An employer cannot make an applicant's religious practice, confirmed or otherwise, a factor in an employment decision. That is what Justice said when they went to the Supreme Court, and it did go all the way to the Supreme Court. That's what he said, because they denied it was Justice Antonin Scalia. He did not believe that Abercrombie and Fitch had the right to discriminate against Miss Alof. Did she end up going to work there? Not 100% sure. Did Abercrombie and Fitch pay her money? I'm absolutely sure about that. They paid her about $70,000. And there was, I believe, additional punitive damages that were going to be paid to her as well as a result of their discriminating against her because they assumed that she was not willing to wear it. She never asked for an accommodation, and she never got a chance to ask for an accommodation because they declined hiring her in the first place. So the summary, really simple. Have a dress code? Absolutely. Enforce the dress code? Absolutely. Enforce the dress code to the point where it creates disparate impact, job segregation, does not provide for religious accommodation, is a way of retaliating against employees or a way to harass them. Can't do that. Can't do that. And you must accommodate a reasonable request for accommodation in the event that an employee makes that request. That's part one. Stay tuned. Don't go far. Part two is coming. For You Wear It Well, dress code workplace dress code policies. Again, I'm your host, Stephanie Lomax, with HR Pro for You and your host of HR in the Dark. If you are not subscribed to get these podcasts delivered directly to your inbox, you can do so by going to HRProForYou/podcast. That's the easiest way to get there. HRProForYou.com/podcast. You can subscribe there. And you'll also be able to get additional information from me that I send out from time to time in regards to policies, procedures, and just general HR information that I send to all of my podcast viewers and those that are on my email list. I look forward to seeing you again soon. Make sure that you stay tuned for part two of You Wear It Well, dress code, workplace dress code policies. Have a good evening, everybody. Bye.